in Central and Eastern Europe, and it is jointly organized with the New University in Ljubljana and Professor Jernej Letnar-Černić. The scope of the webinar is following. Various jurisdictions across the world have adopted national action plans in business and human rights and have enacted legislations or are discussing legislative initiatives to regulate companies and prevent adverse human rights and environmental impacts. These developments raise important questions about the adequacy of existing norms and their ability to drive change towards responsible business practices. Whilst much of the focus so far has been on a small number of countries seen as big players, way less attention has turned to jurisdictions in Central and Eastern Europe, in which, however, important developments are currently occurring. The aim of this webinar series is to gather multi-stakeholders from Central and Eastern European jurisdictions in order to provide insights into the current regulatory landscape and the lessons that can be learned from other jurisdictions. I want to thank all of our distinguished guests, as well as the team behind the organizing. It is now my great pleasure to introduce our chair, Laura Inigo Alvarez. Laura is a postdoctoral research and a lecturer in international law at Nova School of Law and CIDIS, the Research Center on Law and Society. She is also the scientific coordinator of the Nova Center on Business, Human Rights and the Environment. Thank you all for being here. And now, Laura, the floor is yours.
Thank you, Roman, for the introductions. As he was saying, today we will look at developments in business and human rights in Central and Eastern Europe. And the idea is to discuss some of the specific developments, but also to reflect about the bigger picture, so as to what specificities or characteristics the region has in the broader business and human rights agenda, and how to move forward in this regard. Business and human rights is an area that is just beginning to attract attention in Central and Eastern Europe. So I think this is a good moment to have this type of conversation. And so for that, we have today 4 speakers. I will briefly introduce them, and then we will start properly. So we have our convener and co-organizer of this webinar, Jernej Letnar-Černić, who is an associate professor of human rights and constitutional law at the European Faculty of Law and the Faculty of Government and European Studies of the New University in Ljubljana, Slovenia. He has published extensively on business and human rights, the rule of law, and human rights law. We also have Olena Ubarova, who is an associate professor, chair of the International Lab on Business and Human Rights at the Yaroslav Mudry National Law University, where she teaches law. She also leads the Projects and Research Support Center at the National Law University. And last year, she was a Fulbright visiting scholar at the Tanner Humanities Center at the University of Utah. Thirdly, we have Beata Faracic, who is the co-founder and the president of the board of the Polish Institute for Human Rights and Business. She is a legal expert specialized in human rights and business, with 20 years of professional experience in public, private, and NGO sectors in various countries, including the Ministry of Justice and the Ministry of Foreign Affairs in Poland, or the criminal justice system in the UK. And last but not least, we have Sinisa Milatovic, who is an expert on business and human rights, and he is currently serving as business and human rights specialist with UNDP. He is responsible for developing a global programming and providing expertise on business and human rights to colleagues and partners in Africa, the Middle East, Latin America, and Eastern Europe and Central Asia. So with that introduction, I would like to ask some questions to our speakers to initiate this kind of conversations or this discussion format. And then we will leave some time at the end for questions or comments from the audience. So I want to start with Jernej. So maybe to help us set the scene, to give us a bit of an overview, could you tell us how do you see the implementation of the business and human rights agenda in Central and Eastern Europe, especially considering the very different historical background of the region, where many countries were part of the Soviet Union, others were influenced by it in political and economic ways. So maybe just to start, Janet.
Sure. Good afternoon. Thank you, Laura. It's a pleasure to be here. It's also an honor for us here in Ljubljana at the university to co-organize this webinar with you guys at Nova University in Lisbon. I hope this is one of the first of many events which will be forthcoming. Yeah, the Central Eastern Europe has its own particularities. Perhaps the common theme of all countries in Central Eastern Europe is that they have a joint legacy. They all were, before 1990, part of socialist communist systems who were systematically violating human rights and also creating common mentality in the institutions, but also in private sectors. One of the illustrations which we still see nowadays in business operation in Central Eastern Europe is that the state-owned enterprises have a very important role, and this goes back to the old times of socialism. Of course, the region itself is very diverse in itself. No, one has to know that, particularly if one compares the states in Central Eastern Europe who are a part of European Union and those who are not. Concerning business and human rights, some of the states now in Central Europe have been quite progressive. In business and human rights, they have adopted national action plans in the last years. Among them, Poland, Czech Republic, Slovenia have adopted national action plans. All of them, they also adopted the first report after the first period of the adoption. And they're quite advanced in a sense that, if one compares the implementation, they all have developed indicators how to measure business and human rights. If one looks at the last report of the Slovenian Ministry of Foreign Affairs, there are quite detailed indicators, how to measure the state's compliance with the commitments in national action plans. This is one development which one can see. Of course, if one goes further east, the situation is quite different. The capacity to advance business human rights is weak further in Eastern Europe, particularly in Southeastern Europe or post-Soviet countries. Many of them have not developed national action plans. Just 2 states have sub-chapters on business human rights in their national action plans on human rights, Ukraine and Georgia. In Southeastern Europe, perhaps the situation is even more concerning because the funders, the EU and civil society from Northern Europe have been, putting money, resources for civil society to develop baseline assessments on the business and human rights. Some of them go back several years, 4 or 5 years, but nothing has been done since then. Particularly, Serbia is one of this example where much is going on in civil society sector, but also in the private sector. Companies are very much advanced, particularly foreign investors, but the government is not on board. The governments in South and Eastern Europe are not on board. One could say that are there any positive examples how to advance business human rights in the region? Well, one positive example could be the influence of EU-based foreign investors, for example, in Bosnia, Herzegovina, Albania, Serbia, Montenegro, where those investors, through their supply chain, they are demanding that their subsidiaries comply with human rights. Not only comply, but some of them, they also report and measure human rights. But one thing I want to add before I give the floor to my distinguished colleagues is that when one considers and examines business and human rights in Central Eastern Europe, one cannot go without mentioning the deficient rule of law, weak rule of law, weak state institutions, and of course this affects how the business and human rights standards are then translated from theory into practice. There is a lot of collision of state and business interests. Olena, I'm sure you will mention there is a presence of oligarchs, tycoons, who use their business empires to influence public opinions, and also some of them to win elections, as we have seen in post-Soviet Eastern Europe. So there are many challenges, and the region itself is particular. And here I want to emphasize this because sometimes my colleagues, my friends from Northern, Western, Southern Europe, they ask why Central Eastern Europe should be treated differently in business human rights discourse. Well, one of the reasons is that common legacy, common heritage, but also common feature of weak rule of law, weak state institutions, and there are no commitments on the part of government to advance business and human rights. Trade has priority over human rights, sustainability, and other social criteria. And I'll stop here. Perhaps I can add something at later stage. Thanks.
Thank you, Janet. And actually, I think it's interesting to see these common heritage links and maybe also these challenges on the weak institutions, also difference between the EU member states, the ones are not. And maybe I want to ask a question to Olena, maybe to complement a bit what you have been explaining. Even there are these challenges, I would like to ask maybe what could be the main priorities of the region, or what should be the main priorities of the region considering these challenges in terms of the implementation of the UN guiding principles. Maybe if Olena.
Yeah, thank you very much. No, actually, I would like to talk about different context if we are talking about main priorities, because if we are talking about ideological context, I would say that first of all, our societies still have something like post-communist syndrome, I would say. It means that free market, freedom of entrepreneurship is considered as something sacramental. And our governments are in the permanent process of deregulation. And any attempt to start conversation about business responsibilities, to respect human rights, and about hard law regulations are perceived as a threat to the capitalistic order, which in turn is perceived as a threat to democracy. And from this perspective, the key priority I would say should be to raise awareness that actually business and human rights agenda is not about threat to democracy, and it's not about threat to the capitalist order in that manner that could be considered in our societies. And as a result, business and human rights discussions in the region are very careful discussions about how to make this topic interesting for businesses. And in other words, how to sell human rights to businesses, and even human rights defenders use this formulation, how to sell human rights to businesses, and how to prove to such businesses that human rights are beneficial. And actually, I think that this approach could be used, but we should understand, and one of the key priorities should be understanding of dangerous of risks of such approach, especially for our region, because our region is a region without a strong tradition to respect human rights. And even those international and national actors who work with this topic in the region mostly try not to discuss this topic in the context of the negative impact of business on human rights, and very often discussions are focused on business benefits from this agenda. But if we are talking in a more specific way, I would say that the key priority is policy coherence, and I could take Ukraine as example. We have a lot of program documents in Ukraine, and I know that many other countries in the region have the same situation. And to be honest, I'm willing to bet that no one in the country knows exactly how much program documents we have. I tried to count a couple of years ago. I counted 100 and didn't continue. So it's really hard to say if a national action plan, for example, national action plan on business and human rights, could be an effective tool for Ukraine, because we could have such policy, but we have not any guarantee that it would be taken seriously by our state, by our society, by our business, and so on. And actually, as Yerny said, Ukraine has the chapter within the National Strategy for Human Rights, the BHR chapter, and it was adopted in May 2021, and it was really a huge event for BHR, quite a small BHR community in Ukraine, but it was really important. But when National Action Plan to implement National Strategy for Human Rights was adopted, we saw that just one action to implement business and human rights chapter was adopted, and this action is about to study best practices. And it's a really strange approach, because actually I was sure that we studied these best practices last 5 years in Ukraine, and we could move forward. And actually, the Ministry of Justice was responsible for the National Action Plan to implement National Strategy for Human Rights, and the Deputy Minister of Justice participated 2 weeks ago in the Kharkiv Forum, in the panel discussion on business and human rights, and she said that actually Ministry of Justice is responsible for the broad policy for human rights, but it's not responsible for business and human rights, and Ukraine actually still needs to have responsible governmental institution for business and human rights. And it's about policy coherence as well, because actually any governmental body, despite we have BHR chapter in the national strategy, is responsible for this direction. But if we are talking about key challenges in the region, and Yerny said about the most significant challenges, I would say that national action plans or any other business and human rights efforts in the region should pay special attention to state-owned companies, of course, to the investors and banks of development impact. We have examples as positive and negative impact, extractive industries and other sectors that have major impact on human rights. Labor rights, of course, discrimination of vulnerable groups, and role of human rights in trade unions.
Thank you, Lena. Actually, I think you mentioned two ideas that are actually also common to broadly, globally, is how to make the business and human rights agenda interesting or attractive for businesses. I would say this is a common challenge, and as well about policy coherence as well. And I would like to look as well to the third pillar of the UN Guiding Principles, that for me is always key when we are talking about the implementation, and it's the access to remedies. And in this case, maybe a question for Beata. Although they have already mentioned some of these challenges, what do you think are the main obstacles in the access to remedy for business-related human rights abuses in the regions? Whether you see same obstacles and some specific ones as well?
Many thanks, Laura, and once again, thank you to inviting me to this discussion. I guess I should start really with what already was mentioned, because the issue of rule of law and access to remedy is just so intrinsically linked that you cannot separate one from the other. And so obviously the weak rule of law, and sometimes unfortunately reversed trend in the rule of law, kind of with situation worsening, kind of also in Poland. In this respect, naturally this affects the ability to access your remedy. Like even in Poland, we've got currently the situation where a number of judges are, well, let's say we have so-called doubler judges in the Constitutional Tribunal who shouldn't be there. And now we have the whole issue of whether in the future judgments issued by, with the participation of those judges will be valid or not. And this basically raises a huge question for the certainness of the judicial process in Poland. So there are a number of issues which are naturally linked to this very broad concept of the rule of law as well, and independence of judiciary. And naturally the situation will differ country to country. Like 5-6 years ago, I would say that Poland has a very stable judiciary system, and there is nothing to be afraid of except for the length of proceedings. We are in totally different situation now, and we also see the worsening of the situation also in Belarus, and luckily it's not across the region, this trend. So that's also important to mention, that a number of countries are actually undertaking a number of reforms of their judiciary that are strengthening the system and making it more transparent. Obviously, corruption issues and at least perception that corruption is widespread in the judiciary, in the court system, that's one of the major issues that needs to be addressed naturally. But as said, in different countries, there are different rules, measures undertaken to try to tackle this problem. But focusing only on the judiciary is just one part. Naturally, there is a problem with length of proceedings across the board, I would say, across the region. That's partially to do with the financing of the justice system and the number of judges, and also the whole support system and how the courts are organized. And when you look into the database of the European Court of Human Rights, you will see that a number of countries have plenty of cases concerning the length of proceedings, which naturally affects the access to remedy, because like if you are dismissed today and you are waiting for 2 years for your court case to be heard by the labor court, and then you kind of wait, it takes another year, perhaps longer, to have this case actually solved. I mean, 4 years later, well, you will have the judgment, but you have to leave of something now and not in 4 years' time. So naturally, this length of proceedings is also affecting, whether you can talk about the effective access to remedy or not. Having said that, at the same time, we've got very low legal awareness across our societies. And probably it might be, there are some countries where it gets better, but my feeling is, and I think seeing that Elena and Jernej nod their heads as well, this is a problem across all the countries. And this has a lot to do with the education system, which just doesn't pay attention to it. And this needs to be addressed, I would say, pretty much in the first place, because unless people know what rights they have, they won't feel empowered to actually demand them and try to get them actually obeyed and respected. We do have additional kind of paths of recourse. So in pretty much in majority of countries, there are national human rights institutions to which citizens, and not only citizens, can lodge complaints against, like if their rights are violated. The problem is that they normally can handle complaints only against state institutions. And it's not that they can tell those institutions to, behave specifically in a given situation, but they can point to the issue and recommend some changes. Naturally, again, those mandates will vary. There will be some which will have more kind of power to actually even impose fines in specific situations. There are some which, like Moldovan NHRIs, that can handle complaints from individuals, but then again, say against private enterprises, but then it's not that they will be able to issue a fine for the company. They will be able to kind of engage and perhaps also raise the issue, if it's more of a systemic nature, also with the relevant ministries. On top of that, we do have NCPs in several countries across the region, also kind of looking into Turkey, also looking so kind of a bit outside of our area and also more to the east, so towards Kazakhstan. But there aren't that many cases. And to be fair, I guess the more correct phrase, there are very few cases. Again, part of the reason being people just simply don't even know that there exists such a thing as NCP. They wouldn't know that they can submit a complaint and that this is free of cost most of the time. And they don't know that even if in their country there is no NCP, then they can, but their rights were violated by a company, by a foreign company operating in their countries, that they could lodge complaint to the NCP in the other country. So again, we are kind of going back to the point of people just not being aware of their rights and venues of routes. And to be fair, that goes, it's the same for companies. We had a case which was actually quite interesting, which was submitted to the Polish NCP and by a company which against a company that states in its CSR report that, oh, we comply with international standards, including OECD for multinational enterprises. But their lawyers were actually very surprised when they got into the meetings that actually there is such a thing, that, that there are some strange proceedings led by NCP with secretariat located at the Ministry of Foreign Funds and Regional Development. And so, it just tells a lot, right? So if we want to see this complaint mechanism to be more efficient, we also need to kind of make sure that we speak more about it. And then naturally, another route of accessing your rights would be to lodge complaint with labor inspectorate, labor inspections. There are different names, but the point is that there's in majority of countries and institutions that oversees if the workers' rights are respected and checks the health and safety, if the health and safety regulations are followed by the private sector, but also by state institutions. And here again, the situation differs a lot because majority of those labor inspections can only check situations of those workers that are employed on the labor law contracts. The problem is that across the region, we've got plenty of people working on the basis of civil law contracts and in the gig economy. So basically, it's, I would say, majority of people currently in Poland not being covered. So you've got, in a way, you've got a system, but it's got plenty of loopholes in it. What is, however, slightly more promising is that at least in Poland, but I also know that in one other country in the region at least, we see the movement of people who are self-employed, but kind of they're self-employed because that's the only way that they can work with another company, because companies are trying to externalize the cost of social benefits and so on. So they're kind of saying, yes, we want you to work for us, but you need to self-register as self-employed, and then will kind of enter into B2B contract. So we see that those people are finally getting kind of organized. And Poland, for example, a couple of weeks ago saw the registration of a trade union of self-employed personnel, and we are really kind of looking forward to see whether it will have impact and whether this labor a trade union will be kind of treated really as a representative of this group or not, and we'll see how many people will actually join it. So, but yes, there are some trends, and I'm mentioning trade unions because that's very often also another partners that can help individuals access, a fight for their rights. Thank you.
Thank you so much, Beata. And actually, I was listening to you when you were referring to the NCPs, and sometimes the issue is that the lack of awareness of parties and on different stakeholders, and not only there, but we also have this issue in the south of Europe, especially in Spain and Portugal. I have another question that maybe I can ask to you now. And I think you kind of refer a bit, but I was wondering in relation to the last Polish court decision on the supremacy of the Constitution and whether you see potential implications for business and human rights.
Thanks.
Okay, not sure if you want to talk about.
No. I just mean that I'll answer very briefly, because if you would want to go into detail of discussing it, we'll spend the next few hours discussing it, right? I mean, naturally, it will have impact because, like, the judgment also says pretty much something along the lines that, some provisions of the EU law are kind of not above the Polish constitution. So it kind of tries to find some sort of strange legal reality. So in a way it has, because like if there will be a political will for the Polish Constitutional Court to issue judgment that will say that specific, specific provisions of European law are not applicable. And this will happen to be of relevance to how you conduct business, and naturally it will have impact. It will have impact also because at the moment a number of structures in the Polish constitution, in the Polish court systems are affected by the deforms of the current leading party. So, I mean, it's not that this only will have impact. A number of decisions have impact, and we've already seen court cases where entrepreneurs are cases were assessed by those doublers in the Constitutional Court, and they are kind of like raising the question, are those judgments at all valid? So it has already started to bring instability into the system and kind of put a question mark on whether specific judgments are, and I may say English word, but let's put it valid and final or not. So naturally it will have impact, but let's see and wait. I mean, I'm afraid my political imagination grows bigger and bigger with every day. So I'm afraid we haven't seen the end of this story yet. So.
Thank you, Beata. And now also turning to Sinisha, maybe I would like to also ask his point of view on these challenges in the region, and in particular, maybe how the pandemic has affected business and human rights issues, in particular in Central and Eastern Europe.
Thanks. Yeah, thanks for the question. I mean, the brief answer is, like everywhere else, it's a setback. COVID-19 has been a setback for business and human rights in the region. You could obviously look at, the basics of business and human rights are relations between workers and companies, and they've been negatively impacted. They've been challenged, I mean, the social contracts have been challenged by COVID-19. There's a range of labor rights abuses and human rights abuses that was referred to by my colleagues just, prior to me. So lack of decent jobs, a lack of respect for labor rights at the workplace, health and safety, freedom of association, and so on, widespread discrimination in the workplace. All of these have been negatively impacted. Forced labor remains high. and so on. So the brief answer is that essentially, obviously, COVID-19 has been very challenging for the region, and we don't see that trend necessarily improving. A more optimistic view, you could say, is that the baseline was so low in terms of the agenda, the awareness of the agenda, and so on, that it's not necessarily a huge setback for the business and human rights agenda, even though obviously it is for the rights of workers, communities impacted by businesses, and so on. So in that sense, it's not as if, you know, some huge gains were lost necessarily in terms of, you know, creating legal and institutional frameworks to deal with business and human rights, to promote it, to you know, promote the implementation of the Uruguayan principles. In that sense, I mean, I guess that's maybe, you know, an unrealistically optimistic view, but I mean, that's, you know, essentially a more optimistic way of looking at it. And I think looking forward, you know, when the COVID-19, I guess, when the pandemic, you know, subsumes and we start to so-called build back better and so on, the region will be, you know, similarly positioned to where it was in terms of promoting promoting change through the business and human rights agenda. So, I mean, I'll keep it brief. I don't want to take too much time. I think there's lots of other issues to explore, but I mean, that's the reality of the situation right now.
Thank you so much, Sinisa. And I would like to also dive a bit into some of the specific legislative developments in each of your countries, particularly considering sometimes there seems to be less attention in other regions. And maybe also we probably have a diverse audience from different parts of Europe and beyond. So maybe a common question for Olena and for Janet, maybe if you can explain the legislative developments or normative developments in business and human rights. Olena, in your case, in Ukraine, and Janet in Slovenia. Maybe if you can provide some examples as well. Maybe Olena can start.
Yeah, thank you for this question. Actually, I have one, I think, good illustration of my previous comment that of how de jure and de facto these are two parallel realities. Quite often in Ukraine, unfortunately. For example, 2 weeks ago in Ukraine, the anti-oligarch law was adopted by the parliament, and actually this is a huge issue for Ukraine, and it impacts business and human rights agenda very much, because actually if we have oligarch structured economy, it's hard to make important the agenda on business and human rights, because actually big companies are not interested so much, for example, in foreign in foreign investors and so on and so forth, and they have very huge political influence, and they could impact to our legislation, to our parliament, to our judicial system. And the draft of this law was prepared and proposed by the president of Ukraine, and huge attention from society is going to this draft, and according to this law that already have adopted by the parliament, according to this law, the National Security and Defense Council will form the register of oligarchs. We have indicators who are oligarchs, and this register will be in open access, and actually the president of Ukraine is the head of the National Security and Defense Council, so it's not quasi-judicial institution, and it's not a judicial institution. So it's a very specific institution, and actually the president controls the work of this agency. So we have very active discussion in Ukrainian society, because from one side, actually, Ukrainian society feels that, of course, we need to change the structure of economy and the structure of actually whole governance in Ukraine. It should not be it should not be based on such oligarch system, but from other side, human rights defenders, civil society organizations, expert community criticize this law a lot, because actually it violates the rule of law requirements. And we have this very controversial situation. And one more scene, 1 week ago, President Zelensky and some other persons who are high politicians in Ukraine became the key figurants of Pandora Papers. Our previous president was figurant of Panama Papers, and unfortunately our current president is figurant of Pandora Papers. And it's, of course, it's a very big challenge again for trust, for society trust to any such initiatives, because we see this contrast between some initiatives that could be good and the realities that we have in our society. But if we are talking about some positive examples, I could tell about, I think, very good initiative from our national contact point, OECD national contact point. They have initiated to prepare the business and human rights guide for state-owned enterprises in Ukraine, and it will be approved by the order of the Ministry of Economy. So it will be a guide that will be obligatory for state-owned enterprises, and in the context of the importance of this sector, of these actors in our economy, it will be really significant step.
Thank you, Janet.
As far as yeah, thanks, Laura. As far as Slovenia goes, Slovenia 3 years ago adopted National Action Plan on Business and Human Rights after much discussion. It's a decent national action plan, even though it doesn't include commitments as to the Pillar 2 corporate responsibility to respect. But in these 2-3 years, the Ministry of Foreign Affairs really pushed the envelope further. It organized annual forum on business and human rights, and also it developed a statement for major Slovenian companies to sign. And as I mentioned earlier, also the first report on implementation is already adopted with indicators, measuring the compliance of Slovenian state-owned companies, but also companies in the private sector. Again, it's a decent report, at least in my opinion. Of course, much could have been done better, but of course there are many challenges ahead, many opportunities to improve that. Now, Slovenia, as some of you know, at the moment is also presiding EU member states of the Council of the EU, and in this role, the government really pushes the commitment towards the recovery after COVID, or in the last phase of COVID-19. Of course, also emphasizing green policy, sustainability. There is no mention of business human rights, but it's indirectly there. I would like to see more direct references in the policies of the government and Ministry of Foreign Affairs in this respect. if you ask me if Slovenia has a position as to the EU's Parliament proposal for the EU directive on mandatory due diligence, it doesn't have a position as yet. Of course, there is a similar position. It doesn't have a position on UN Treaty on business and human rights. So it's a common position which many of Central Eastern European states have. But Slovenian companies, when they do business, they mostly do business with, Germany, France. But of course, they are very active also in Southern Eastern Europe, but also in Eastern European markets. And just last week, there was a EU-Balkan summit here close to Ljubljana at Brdo pri Kranju, where EU committed 30 billion euros of investment into Southeastern Europe, mostly ex-Yugoslav state plus Albania. Again, there is no direct reference in this pledge, this declaration to business human rights, but there is a mention of this investment being subject to the sustainability requirements and also rule of law. So I hope the EU will really, condition this aid with at least, I would really wish that the EU, but also the Slovenian presidency requests, the countries such as Bosnia, Herzegovina, Serbia, Albania, Kosovo, Montenegro, and North Macedonia to finally adopt national action plan on business human rights. I think this is opportunity also for UNDP to work with the European Commission to persuade the governments to adopt this declaratory programmatic condition. In the private sector, Slovenian companies are active in Eastern Europe, in Southern Eastern Europe, and it seems that they apply different standards abroad than at home. At home, the standards are quite strict as to the human rights protection, anti-corruption, environment. The courts are very much also enforcing those standards in labor, administrative law, also commercial codes. But then the challenge for Slovenian government has always been, what should be position as to the extraterritorial obligations of companies doing business, for example, in Ukraine, Belarus, Russian Federation. Many, especially Slovenian pharmaceutical companies, the largest Slovenian companies are pharmaceutical. They do business a lot in those countries, and of course, as Olena, Beata, Sinisha know, the way of doing business is a bit different in further Eastern Europe. There are different mentality, different practices, how to go about the business. Slovenia has national action point under OECD guidelines. It only dealt with one case last year concerning one investment by British corporation Ascent Resources into the extractive natural resources in Pomurje region in Slovenia, but the complaint or the specific instance was thrown out by a Ministry of Economy. I would also wish that Slovenian national action point would be more effective. In Slovenia, there is an important part of the industry is state-owned. So state still has a lot of investment in the industry. And myself, and also I see Gorazd Justinek, my colleague, also in the audience, we have been pushing the last 2 to 3 years that Slovenian agency or a sovereign holding of Slovenia, which it's a public-owned company, state-owned company, which manages the investment of Slovenian state in the economy. That company updates and renews the normative, basis for its functioning. Of course, the company cannot really interfere with what management boards and supervisory boards do in state-owned companies, but nonetheless, the sovereign holding corporation adopted renewed standards of codes of conduct for Slovenian state-owned companies, which also include reference to to business and human rights, also to UN guiding principles and human rights. Not all what is there in the codes of conduct has been translated into internal documents of those companies, but at least some steps are being done. One of the challenges I see in the private sector in Slovenia, in state-owned, but also in private sector, is how to move beyond from mere reporting on non-financial indicators. Slovenia, as a member state, the largest companies, they have to report on non-financial indicators of their business operations. But one of the challenges I see here is how the companies will move from reporting to measuring their impact on the human rights environment and also rule of law in Slovenia. I think that will be a challenge for many of the companies. They're not many companies which do that as of yet. There's one energy company and one insurance company which have advanced reporting and supervision of global supply chains mechanisms, but most of them, they just fulfill these requirements under the non-financial reporting directive, EU directive, and this is a challenge. So Slovenia is perhaps is a success story in the business human rights, at least in theory, in formal documents. But I would like to see more commitment by the companies themselves and also the government as to the extraterritorial operations of Slovenian companies in Eastern Europe.
Thank you, Janet. Actually, there was a comment in the chat, if you can maybe share the link to the reports from Slovenia. And I want to remind also the audience to post the questions in the Q&A tab, although I will ask some of these questions at the end. And also maybe to Beata, I know there is also the Polish National Action Plan that has been adopted. And maybe if you can tell us also a bit about the process to adopt the Polish National Action Plan, and maybe you can talk about the participation of the trade unions, because as far as I know, it's the civil society organizations and the trade unions that have been quite active in pressing the government to develop the National Action Plan.
Yes, indeed. We did have a national action plan from 2017 till 2020. And currently I'm being told that last week, Polish Council of Ministers have adopted the second, but I still need to see it. So yes, but at least I've got confirmation that it supposedly was adopted. So I wish I was so optimistic about it and positive as Jernej was about the Slovenian one, because, I think we should make a difference in Poland between the first NAP and the second NAP. The first NAP was indeed like the first announcement that it will be developed came in 2013, but it wasn't developed until 2017, simply because there was no readiness, I'd say, like within the administration as to who should pick up the lead, who should be the leading ministry on that. So it took quite a few years before actually Ministry of Foreign Affairs said, okay, we'll coordinate it. We are not responsible perhaps for implementing all of those issues. In fact, we hardly are responsible for anything except for perhaps implementing some activities within our own ministry, like inserting social clauses into public procurement or training ambassadors on UNGPs, which they actually did. So it took a long time. And then when it came to developing it, like the first draft, there was no national baseline assessment developed in the meaning, in the way that we would understood national baseline assessment. What was done was more of a capturing status quo by the ministries. And this, in a way, also formed part of the National Action Plan. So it was not really an action plan again, as I would understood it, in the form of commitment, allocated ministry, and the deadline. It was more of a narrative, around 60 pages document, which said, okay, in Poland, we've got those regulations and we have done that, and we are planning to do this and that. There are a couple of relatively soft commitments, which, to be fair, weren't met, except maybe for one or two. And obviously, there was a report from how NAP, at what stage all of those commitments are, but it was quite a nice narrative story about what was done, and nothing that I would say was developed along specific indicators, unfortunately. And in the process of preparing this first NAP, there was an opportunity to comment on the first drafts of the National Action Plan, and indeed there was even a meeting organized where NGOs and also representatives of trade unions could take place. So unfortunately, it was not a process led in a way that could engage different stakeholders and which could serve as also at times that could be a raising awareness period for a number of actors. Like definitely the same goes for business. They were not consulted in a way, so except for being provided with the draft version on which they could comment. At least the period during which it could have been commented on was relatively long because it was about 1 month. And now when it comes to the second NAP, I mean, it's pretty much the same story, except that there was no meeting also due to COVID. But again, it could have been organized to discuss it via Zoom. We all know it, but it wasn't. And this kind of reflects also the changing reality when it comes to the administration over the last month. So I wish I could say that, yes, the first NAP was not perfect, but at least it was a period during which at least some parts of the administration had their awareness raised and some understanding gained about what business and human rights is, and because that's a fact. But I wish it was different with the second NAP, because now the second NAP you cannot justify with, oh, we didn't know how to do it. It's just a, unless the draft which we commented on of the second draft, of the second NAP, was not changed significantly, it will be again a very weak kind of narrative document with not much, if any, commitments. So in this way, if that's the case, it will be opportunity loss. Again, because the process which could have been used to really engage different stakeholders, make some collaborations work, just wasn't used as such. And I wouldn't blame the people who are doing it, who are responsible for the process. They are working within specific limits, which are and reality of the ministerial work, which is currently in place. So that's when it comes to NAP. I mean, there is more positive story to national contact points, luckily, because the point has been very active. They were improving their policies and procedures. They were undergoing trainings to be able to do properly the good offices and to engage in mediation and offer some mediation services. So on that front, a lot has been done. And I have to say that we've been very cautious at the beginning, because again, the Secretariat is located within the office of the minister, and that's Minister of Funds and Regional Development. But I have to say that the cases that were handled so far, they were handled in a very professional manner, and we cannot say that there was any bias. It seemed that really Secretariat took it very seriously, and even though we have already now 2 cases, one which was already finalized and some points kind of agreed on, the second now accepted in March 2021, where except for admit kind of providing information, yes, that there was a case submitted to us, but we cannot disclose the parties because we've agreed on confidentiality to enable that the process actually has chances of succeeding, right? I mean, the point in the NCP proceedings is to find solution. And sometimes going open with who the parties are could already damage this process. So I'm actually perhaps a bit contrary to the normal official position, for example, of the OECD Watch and so on. I do actually think that it's better to have confidentiality on the case for a certain time, and then at least have a chance of finding solution. And we've seen that it worked, at least in one case handled by the NCP, this has worked. So this is positive. We'll see whether it won't change in the future, right? Because again, this positioning within the cabinet of the minister, it has its advantages, particularly when you have companies being asked to come to the ministry, to the meeting, because it kind of shows that it's being treated seriously. But it can be also a situation where, if something changes when it comes to the political leadership again, and I mean kind of at the personal level, this might affect the way that NCP works. So kind of structure-wise, it's not ideal, but for now it works really well. So that's the situation for now.
Thank you, Beata. I'm happy to see some positive developments at the level of the NCP. I think it also depends a lot on the different institutional structure of the different NCP, the way it works. And I think this is one of, yes, exactly, and the people and the resources, of course. But I think it's a good, what you were mentioning about the training, because actually this could be a good practice as well for other NCPs. And for Sinisha, since you are currently working at the UNDP, I would be curious to know more about what has been the role of the UNDP in advancing the business and human rights agenda, in particular in Central and Eastern Europe, maybe in other regions, but maybe if you can talk a bit about the actions in the region.
Sure. Well, thanks for that question. So in brief, UNDP started a kind of let's call it a regional program in Asia 5-6 years ago, where it has now evolved to 11 countries, where it is principally helping governments develop national action plans. That's number one. Number two, working with civil society and NHRIs, especially national human rights institutions, to help victims of business-related abuses obtain access to remedy. And then third, working with corporations as well, through training them on human rights due diligence and providing, let's say, other kinds of advice in getting them to implement the UN guiding principles. So this program is being scaled up globally. And last year we had our first regional forum on business and human rights for Eastern Europe and Central Asia. Now that's a region, the way that UNDP's regions are divided, we cover countries that are not in the EU, even though the experiences of countries in the EU are welcome and are a good pointer and are relevant, but we don't have country offices, let's say in Slovenia anymore, or in Croatia, our country office closed when Croatia joined the EU. So the first regional forum last year focused on essentially, and that's our mission right now, considering the state of business and human rights in the region, raising awareness, getting people to network, just like this event. Forming a kind of a community of practice on business and human rights between academics, practitioners, companies, governments, civil society, and HRIs, and so on. The idea being that, we need to form a kind of a critical mass, and we know where we were in Asia 6 years ago in our inaugural forum. There were 120 people. Now there were over 6,000 people last year. It was a virtual forum, albeit, but at the same time, the discussion has evolved so much that we are aiming to, let's say, replicate or get near that kind of level of evolution of awareness and of thinking and of practice as we've had, for instance, in Asia, and are now having in Africa as well. So that's essentially our role. We have country offices, we support programming, we support civil society organizations, national human rights institutions, and for instance, in Ukraine, we're developing a business human rights program. In Turkey, we have trained companies on, using a tool that we developed called a rapid self-assessment on COVID-19. The idea being that companies can essentially assess themselves in terms of their compliance with their obligations under the UNGPs. So in brief, that's the framework. If you'll allow me, I mean, just to reflect on some of the discussion in the chat, Ekaterina mentioned this selling human rights to business, and then Olena reflected on that. So I thought it would be interesting just to say a bit about that. Selling human rights to business, selling business to human rights, and so on. I mean, I think broadly speaking, let's say there are three ways of, changing the situation. Three, let's call them theories of change, if you want to use a pretentious term. One is essentially that, you have businesses seeing benefits. Is this idea that you're selling human rights to business. Now, this is tough when there is, well, first of all, there's little empirical evidence, not just in our region, but elsewhere, that, businesses profit from improved human rights practices. There's anecdotal evidence, but I don't know myself, at least when I was doing academic research, that there was strong empirical evidence. That's number one. Consumer organizations are weak. So, getting businesses to see the benefits, I mean, it hinges on the idea of reputational risk and so on, lots of consumer pressure. And that is not necessarily so present in our region, at least certainly not when it comes to labor rights, perhaps a bit more when it comes to the environment and the impact on the environment, but on labor rights, hardly. A second way, let's say a second pathway for change is obviously pressure from workers, from civil society organizations. Again, this is tough when trade unions have been co-opted. We haven't discussed this much, but it's definitely a finding, that we've discussed amongst ourselves at other occasions. Trade unions are not necessarily, it depends on the trade union, depends on the country, depends on the specific circumstance, but they're not necessarily the champions of change that you identify them with when it comes to this area, at least. Civil society organizations are finding it tough because civic space is shrinking, as we talked about. So this second pathway is again limited. We have awareness raising events such as this and such as our forums that I mentioned. And by the way, I should say that we are going to send a save the date, publicize it today. Actually, our forum will take place, our second regional forum on business and human rights, second UN forum that we're organizing actually with the UN working group, will take place on the 11th and 12th November. But all that being said, all of this is helpful, but obviously insufficient. The third way, we've discussed laws and policies and so on. It's just that laws and policies in our region, especially non-EU member states, these laws and policies are lagging behind. They're kind of lacking, so we haven't seen this kind of uptake of green policies. As Jerne mentioned, Slovenia is, as a presiding country of the EU, has, talked about it, but there hasn't been this kind of great push for, let's call it a Green New Deal or what have you, in the region at least. The one hope that I can see, the one hope, but the main hope that I can see is the spillover effect of mandatory human rights due diligence laws, both in EU member states and the upcoming EU legislation, whatever form it takes. And we, I think, need to discuss the implications of mandatory human rights due diligence on our region. Obviously EU member states, it's direct, but non-member states, who are on the periphery of the EU, who have close links, it's indirect, but it's there. And considering the weakness of all these other approaches, considering the shrinking civic space, considering the weakness of the trade unions, considering the let's say, difficulty of presenting a selling human rights to business case, it doesn't mean we should put our eggs in one basket. I'm just saying that, this is definitely the main hope that we have right now, it seems to me, at least in the short term. Doesn't mean that things don't change, but I think we need to discuss that. And with that, Beata, I don't mean to allow her to do your job, but I see that Beata raised her hand, so maybe she wants to comment as well.
Of course, Beata, go ahead.
I just wanted to just add to what Nisha just said also about this impact of Green Deal and kind of the realities of companies trying to adjust to it, because what we can see in Poland is certainly this realization that you have to take ESG elements much more into considerations than you did in the past. We do have comments from different CEOs in different business fora that, they probably will need to employ like 10 or more people to actually help with gathering the data and kind of help to report on those non-financial aspects. And even though their understanding currently is much more on kind of focused on environmental dimension, and of this realization that, well, actually there is this S and human rights slowly comes in. It's, but I have to say it's a huge unknown, and companies are really struggling to understand it. And I have impressions that some didn't, it's kind of like unknown, right? It's very few companies that I would say for which it is a known unknown. And, but we do see this impact of the legislation that Sinisha mentioned. And I think there is this very strong link in taxonomy, which I don't think many companies have realized, but there is Article 18, which kind of points to the kind of like minimum standards. And those minimum standards, it's phrased slightly differently, but the point is that basically in order to kind of be rated well under taxonomy, you need to respect and you need to implement and be compliant with UN guiding principles. And, you know, it's kind of Article 3 referring to Article 18 and so on, referring to external standards. But this link, I think, will finally become more noticed by the companies when also EFRAG will come up with their suggestions of the reporting standards as well. So I have to say that I put quite a big hope in the changes that this legislation has the chance to bring. Thanks.
Thank you, Beata. And maybe due to the time, and I think it would be good to have like a concluding round. So maybe the idea is to reflect how we can move forward, or what is required to move forward the business and human rights discourse in Central and Eastern Europe. And I would be also curious to know your take on the human rights due diligence legislation as well. So maybe Olena wants to say some final remarks. I will open the floor in the end for questions as well.
Yes, thank you. Thank you. No, actually, just one thing to continue this discussion with Ekaterina in the chat and that Sinisha supported. No, actually, I think that it impacts as well on the role of civil society organizations, this approach of civil society organizations in our region, because actually I think this is could be the discussion if civil society organization want to be something like watchdog related to business abuses, related to violations of human rights by businesses. We could not, I think that we could not consider the same civil society organization as something like company consultancy and to assist businesses to have benefits from implementation of human rights policies and so on. So I think that this is two different roles, and it should not be combined, I think. But no, it's about approaches that will be the basis to develop this agenda in the region. I think as for mandatory human rights due diligence, that could be adopted in the European Union. No, I totally agree that it could have positive impact in Ukraine in particular, and in Armenia, I believe, in Georgia, in Moldova. So yeah, it could be a really positive step for our region. Yeah.
Thank you. And Janice, maybe you want to share?
Yeah, thanks. Perhaps I can also address some of the questions in the,
yes, indeed.
In the chat. What Katya and Ron asked concerning the impact of private sector on the regulation. I mean, I mean, the gist of the challenge in our region is that, foreign investors, why do they decide to invest in Central and Eastern Europe? And to much extent, the main reason is to decrease the cost, because the labor cost is, it's lower than in Northern Europe. So a lot of EU investors are looking for, decreased cost. So this perhaps is not incentive for, for businesses to bring about positive change. But on the other side, all the foreign investors, mostly from the EU, they want stable environment. They want rule of law to be respected, that their investments are protected. So I would say, if I answer to you, Ron, their impact is, in a way, it's a positive. At least in Southern Eastern Europe, a lot of transnational corporations based in EU, they brought about a positive change. And I can give you 3 examples for the sake of time. There is a global corporation called Titan International. It's a cement company, extractive industry company, which owns a subsidiary in Kosovo. It's the subsidiary called Shazam, and that corporation has very detailed supply chain management, not only reporting on non-financial indicator, but also measuring in their annual sustainability reports. And there's another example from Serbia. It's a multinational corporation called NELT Group, which again has a very detailed supply chain management mechanism, quality assurance mechanism, ensuring also feedback and improvements. And also there's another example from North Macedonia. The largest company doing business in North Macedonia, it's a chemical industry company. It's a British company called, if I'm not mistaken, John Matty. And they also, due to the industry requirements, they have very strict mandatory due diligence. They really, put emphasis on the fact that suppliers comply with human rights and environment, emissions, lowering carbon emissions. So there is a trend, and this perhaps, Laura, is a positive message, not to end on a positive note. There is perhaps a change that private investors, mostly from the EU-based countries, they can bring about change in Central Eastern Europe. There is at least partial evidence to this regard. Of course, I mean, a lot depends also on the stakeholders. It's unfortunate that all the developments and all the advancement of BHR in the region is mainly done by civil society, international donors. Definitely, this is not the way to move forward. We need more commitments from the governments, and perhaps this EU pact, EU agreement with the Balkan countries is opportunity, also to pressure the governments to finally adopt national action plans, and perhaps also later to internalize, all the 3 pillars into BHR in the region.
Thank you, Janet. I see you are already addressing some of the questions from the chat. I see Beata.
Yes, I just wanted to add that what we can see, obviously it was very, there were a lot of articles about Poland and LGBT issues over the past years and different situations. It's what we could see, for example, is that there are a number of companies that are trying to go against the tide and that are implementing a number of policies and that they are undertaking efforts to try to make their working place an inclusive space for everybody. I mean, including LGBT people, including people with disabilities, and so on and so on. So I have to say that I really can see plenty of positive action from within. It might not be as coordinated and so visible outside. If you don't know that something is happening, it's it's not necessarily always on the front pages of those institutions, but like obviously IKEA is doing a lot of work on it, BNP Paribas, NetGuru, which is a Polish IT company, and a number of others. So I think there are plenty of developments also coming from really the corporate side. And I think it's always very important to remember that inside of those organizations, there are people working who obviously want to make their work also a good place. And that's not necessarily always the directions that will be in line with what the board or the CEOs want, but more and more, I think there is this understanding that because, let's say, our political leadership is not really the ones that we would want to take the lead on when it comes to setting different standards. I have impressions that people are starting to feel more responsible and for what space they create around themselves and what impacts their own work actually has. Thanks.
Sinisha, please. You have raised your hand.
Yeah, so I mean, I guess my closing word very quickly, I'll refer to an academic article, and I swear it has a real life impact. So this is a very unique thing, but there was an article years ago on how does international law influence, states essentially. And the typology was threefold. One was persuasion. Obviously somebody, starts believing in human rights and, all power to them. One was sanction. And, we all know what that means. I mean, pressure and so on. And the third category was neither, but is, adopted from sociology, from this concept called isomorphism, and it's called acculturation. So the idea is that you don't want to not belong to a group. There's a group of, let's say, nations, doing something, signing the Convention on the Rights of the Child. You don't want to be left out, whatever you think of the rights of the child. I think the same thing, needs, in order for the same thing to happen here, there needs to be a community built, first of all. And that community shouldn't just involve us as, practitioners, academics, what have you, but obviously needs to involve states to start with. There will be sanction, if you will, at least with regard to companies, not necessarily states, through this mandatory human rights due diligence legislation, sanction of some sort. If you want to, do business, you'll have to do certain things. But when it comes to states, and we all, I think, come down with a view that, this smart mix that the UNGPs call for needs to be smarter, i.e. more mandatory. When it comes to the smart mix and more mandatory measures, if they're not necessarily laws, I mean, at least policies, there needs to be a sort of competition, at least regionally, that we've seen in other parts of the world sparked. I mean, look now at Asia, you had Pakistan adopt a national action plan, Vietnam adopting a national action plan, all in Thailand's footsteps. I don't want to exaggerate the effects of a national action plan, but at the same time, it is a policy commitment. And I think we need to spark that competition internally within the states where, UNDP is active in a lot of the states, as I said, that are covered by today's discussion. We need to spark that competition. That's one of our aims. I can't say that every Minister of Justice, Minister of Economy, Minister what have you, will be convinced about this, business and human rights, whatever. They might not even get it, but they'll know that the country next door adopted a national action plan, and the country next door to them adopted a national action plan, and hey, presto, maybe we should do the same. So I think that's an important element of whatever change is likely to occur, this sort of acculturation whereby countries will hopefully take heed of what other countries are doing and try to emulate them. And let's see what if that can happen in our region. Thanks.
I like the idea of the smarter mix in this case. We have two questions, so I'm not sure if any of the speakers want to briefly address the questions and then we will conclude. So we have one question in relation to the situation in Bosnia, where we can find high levels of post-war syndrome, high level of unemployment, and major problems with migrants, asked by Sania. Any comments on the Bosnian situations? I'm not sure if any of the speakers.
Perhaps I can.
Yes, Janet, please.
Comment on that. Yeah, I think Sania, you're right. Bosnia has many challenges from rule of law, weak institutions, also problems concerning labor rights, ensuring right to living wage, to minimum wage. Then, of course, there are these divisions between two parts of Bosnia and Herzegovina. But at least, perhaps, Anya, there's a positive change, at least in business human rights. Just recently, at the beginning of summer, a civil society organization in Sarajevo prepared a baseline assessment on business human rights, trying to push the government to start thinking, to adopt national action plan on business human rights. In Bosnia, there are many bad and good practices. Good practices, as I said earlier, mostly come from EU foreign investors. But I would say that the way to advance business human rights in Bosnia is basically to pressure the government, but also foreign investors, and for people who live there to request the authorities to improve, to strengthen the rule of law, to strengthen the commitment to human rights and to public interest, to advance the standard of living in Bosnia and Herzegovina. Without that, there will be ongoing status quo in Bosnia.
Thank you, Jenny. Just one final question, if someone briefly can address from Bettina. And do you have a sense of how the EU conflict mineral regulation is perceived and how well it is enforced in EU states? Anyone wants? Beata?
I can answer, but I'm afraid that won't be a satisfactory answer. So if somebody really knows, please add. I cannot unfortunately tell how it's perceived in all the countries across. I would say in Poland, it's still relatively low known, I have impression, but I've noticed that the ministries are trying to provide information on the website, and they kind of try to be quite informative in terms of kind of making this information accessible, also of what is expected. How well it is enforced, I wouldn't be able to tell, I'm afraid, at the moment. So this would require a bit more of a research and really overview across the different states. So yeah, I'm afraid that's the only thing that I can tell at the moment.
Yes, indeed, it's a broad question depending on each EU member state. But I would like to maybe conclude here because we are already on the timing. I would like to thank all our speakers and the audience for the participation. And I will give the floor just to give some final words to our colleague Roman as well. Thank you.
Thank you very much, Aura. And I wanted to also give very warm thank you to all our panelists. I personally learned a lot during this webinar, and now I'm going to go back with a lot of things to reflect on. And also warm thanks to all the attendees, I hope, and for your participation and questions. For those who are interested to follow what we're doing and what we're researching in our Business and Human Rights Centers, I'm going to share right now our website in the chat, and we also have all different social media channels which you can follow us and see what we're doing. So thank you very much, everyone.
Thank you, everyone.
Thanks.
Thanks.
Thank you.
Clara.